Howdy, and welcome to another episode of Cooper's Code Lifecycle of a Case series, where we provide tools and tactics for the different phases of a case. We're compiling all of these episodes into a playlist on our YouTube channel, so head on over there if you want to see them all. One of the things we strive to do at the firm is to have our proactive discovery drafted before we file suit. It allows us to get our notices of depo, our request for reduction, our request for admission, our interrogatories, our person most knowledgeable depositions. All of those get sent out so that we can claim preference. And it also sends a further message, which is this firm is on their toes. Also within the frame of what I would call discovery is summary judgment. Nothing gets one ready for trial the way summary judgment does. I think of it as a way to hold your feet to the fire and to double down on your diligence in terms of being ready for trial. At a certain point in the case, one reaches what one might call formal settlement talks. And these can be a variety of things. These can be conversations back and forth between opposing counsel that can be beneficial to help each side kind of understand where they're coming from in certain respects. The most common these days in full scope litigation is mediation. Mediation is done in the vast majority of cases. There are also mandatory settlement conferences, which are a little bit different than a mediation. Those are ordered by the court. They're usually a little closer to trial. So we'll talk a little bit about the pros and cons of each of these types of settlement approaches. As one gets close to these, whether it's a mediation or a mandatory settlement conference, another thing to think about is when to send out a formal offer to compromise under the Code of Civil Procedure, Section 998. So let's talk about that. And the shorthand term is 998. And this is the tool for what is known as an offer with teeth. So why is it known as an offer with teeth? If you send out a 998 and you beat that number, you get expert costs from the date of service of the 998 and 10% interest from the date of service for that 998. So to put that in context, if you make $1 million policy limit demand and the carrier fails to pay it, then when the judgment gets entered, let's say that it's 2 years later that the case goes to trial and there's a verdict, and you've had to spend $200,000 on experts, and there's another 2 years, you're getting, $200,000 in interest from it, and you're getting $200,000 in costs. So that 998, because you send it out at that time, means that you're getting an extra $400,000 on top of the judgment in that case, presuming you beat that $1 million number. That's the upside. The downside is the defense can do the same thing. Now, they don't get the 10% interest, but they do get expert costs. And so if one ends up doing less favorably, then there can be situations, let's say the defense sends out a $50,000 formal offer to compromise, and it's a defense verdict, and they spend $100,000 in costs, then your client can be on the hook for that $50,000 differential. So 998s are very tactical. They involve a fair amount of thought. One takeaway with 998s, always take a look at the rudder group and the practice pointers and strategy in cases related to 998s. It seems like a new case comes out every few months on 998s, that it needs to include this, or it can't include that, or it must only go to one party, what have you. So while one can rely on one's practice and expertise to make sure one is not making mistakes related to 998s, typically we like to go through the rudder group, make sure that we're meeting all the elements of it so that we don't make a mistake. is if we beat that number, we want to make sure that it is enforceable. There may be rare tactical situations where one decides that one does not want to do a 998. Those are, like I said, they're fairly rare, but they tend to be ones where you might not want the other side to do a 998. So, because if you do one, typically you'll get one back in response. So those are formal offers to compromise. Those are something to think about in the light of formal settlement talks. So mediation. With mediation, the things to start thinking about early in the case are, if it's going to be mediated, usually the answer is yes. And if so, are there certain people who might be better than others? We tend to suggest the other side. If you have names of people who you really like to work with, please share those with us. In the absence of that, here are 5 people who we think might be a good fit for this case. Those are not going to be the same 5 people in every single case. We usually try to make sure that we think about the client, the case facts, the venue, all the various elements that might make for one mediator being better than another mediator. Across the board, one of the things we're looking for when we're selecting a mediator is we want someone who has good EQ, meaning emotional intelligence, and good follow through. There are a ton of mediators out there now at this stage. And I would say that if there are 100 mediators out there, there are about 10 of them who have high EQ and high follow through. The EQ is important because the mediator is going to be reading the room, both our room and the defense room, and they're going to be interacting with our client. And we want someone who is going to honor our client's experience. And we want somebody who's going to be able to read the defense room and be able to tell who's really the shot caller there, where can the pressure be applied. The follow-through piece is because a lot of cases don't resolve at the first mediation. They require someone who's going to be diligent, someone who's going to be doing follow-up, someone who will create opportunities to check in with people or go out of their way at, say, a cocktail party or dinner to come over and say, hey, I've been thinking about you in the X case. Where are you on that? When is that motion for summary judgment hearing? The detailed follow-up people, the ones who never say die, the ones who refuse to have orphans, are the ones who typically get their cases settled. And as much fun as we might have in trial as trial lawyers, it is usually in our client's best interest to avoid trial when at all possible. So don't cave to take the wrong number. Do everything in your power to try to position it to get the defense to understand your story, your narrative, how you think the judgment is going to come in and why, so that the mediator and the defense can honor your client by paying an appropriate settlement in the case. The mediation itself, we will make sure that the client is aware of what the process is going to be like. About 90% of mediations are by Zoom right now. We do like in-person mediations, but it can be inconvenient for some people to do it that way. So we'll make sure that the client knows that there's going to be downtime about the confidentiality of the process. We'll make sure that we let the client know, hey, if there are other decision makers who you think should be there, say a significant other or a family member, we want to make sure that they're aware that this is going on because this may be the biggest decision you make in your life. If there are elements that might benefit from some financial planning, say a structured settlement or other piece, so those are things that we start talking about early on in the process before the mediation itself, so that the client is aware of their options and can think things through and can make meaningful decisions at the day of the mediation. So those are all pieces one wants to make sure that one arms one's client with as one goes forward. Mandatory settlement conference is similar in mediations in certain respects and a completely different animal in other respects. It varies by jurisdiction. A lot of the busier jurisdictions have moved to the mandatory settlement conference being done by volunteer attorneys, and these are oftentimes Zoom, meaning they're done remotely. The volunteer attorney is oftentimes someone who is working towards being a full-fledged mediator. These can be very beneficial. They can be beneficial because you encounter people who are very eager to make a name for themselves, will work very hard, will be creative. The downside is sometimes some of the volunteer mediators aren't as seasoned in the mediation process. And so one might need to help give them tools for resolution. So we've been in MSCs with volunteer mediators where we've taught them things like brackets or mediators proposals or other tools. And you have to teach in a way that maintains their dignity. So do you think that this might be a decent time to consider brackets or a mediator's proposal? Maybe. How do you use a mediator's proposal? What does that look like for you? Which means they don't know what it is and you have to educate them politely. Those are some of the MSCs. There are still some jurisdictions where it's a judge. Oftentimes those are in person as opposed to Zoom. The judicial ones tend to have a much different tenor. Oftentimes, and these are the old school ones of sitting out in the gallery and the lawyers walk back and go into chambers and kind of cycle in and cycle out. Those can be beneficial because the court can oftentimes apply the pressure of the robe in a way that is different than a mediator or a volunteer mandatory settlement conference panelist. So props to the counties that are still doing those. A lot of the great settlement judges are people who went on to be outstanding mediators in the day. The other thing that an MSC can be good for is helping get a better sense of the court and the flow for the case. It's typically much closer as far as the trial date. If you have the benefit of being in person, it allows you to walk around. You can talk to people, talk to clerks, talk to people in the courthouse, get a sense of the flow in terms of what's going through security. You can sometimes talk to the bailiffs or to the people who work security. These are all people where you can kind of get a sense as to, how many cases are really going out? How many judges are really taking cases? I'm told it's direct assignment, but if my judge is mid-trial, am I going to be kicked over to somebody somewhere, down the hall or in a satellite courthouse somewhere? So that MSC is a great opportunity to gather granular information when you're in person. So side note, if you don't have an in-person MSC, make a trip out to the courthouse. Nothing beats going to the scene of the court, not scene of the crime, to be able to figure out how that's likely to go down when the actual trial call happens. Moving on past formal settlement talks, at a certain point in the case, it becomes time to engage in what is known as expert discovery. For most lawyers, the expert piece is going to have started much, much earlier in the case. What do I mean by that? I mean that if this is a product, one probably already has an engineer that has been taking a look at it. If it's a collision, there may be an accident reconstructionist, a human factors expert, a biomechanic. On the injury side, there may be an orthopedist who has taken a look at the client and medical records to render some thoughts on what the future looks like for this client. There may be a prosthetist, there may be a life care planner, there may be an economist, whole battery of different types of experts that provide testimony in these types of cases. It is always best if an expert is going to be needed to bring those experts in earlier on in the case. So in California state cases, the experts are required to be disclosed 50 days before trial. And in that window after the disclosure, their depositions can be noticed. And most of the time, each side takes the depositions of all the opposing side's experts. So in the state court, if you have a lot of experts, this can be a challenge. Why do I say it can be a challenge? If you've got 10 experts per side and you're 50 days before trial, that means you're going to need to get 20 expert depositions done over the course of 50 days. So a consideration with complex cases and talented opposing counsel, you might consider reaching out to the other side and saying, hey, how'd you feel about doing an early expert disclosure? We can agree to it being 100 days before trial in terms of doing the disclosure and taking the depositions over the 50 days, leaving another 50 days to finalize getting ready for trial. So that can be beneficial. It can make life way more civilized. That's one of the challenges with that scramble in state court just before trial, is the way the experts are set up. Another thing that's important to remember in California state court is that there is a requirement that files be exchanged 3 days before deposition. What does that mean? It means that the expert so I'll use the defense in this case. Say the defense has an expert who is an accident reconstructionist. That accident reconstructionist is obligated to take all of their file and make it available, typically digitally, 3 days beforehand. And so this seems to be one of the areas where lawyers have challenges making it happen. And if you hear me being delicate in my language, it's because I want to make sure that I'm not placing blame, because it can be complicated. The complications are that a lot of experts aren't full-time forensic professional experts, which means when you say you need to have your file available for the other side 3 days beforehand, they say sure, and then they don't think of the fact that they keep their time records in pencil on a piece of notepaper next to their computer, or that their files are all over the place, or that they're a nutty professor and they're completely disorganized. So don't get morally offended when the file doesn't show up 3 days beforehand. Do be proactive with opposing counsel to say, hey, I need the file. And one of the first things when the file arrives is to take a look and make sure that it has everything that one would expect to see in the expert file. Frequently, the experts will not include their billing. So, hey, thanks for sending over the file. It appears that the billing is missing. Hey, thanks for sending over the file. Were there any text messages between you and your expert related to this file, or any text messages between your expert and anyone else related to this file? They become apparent in their absence, I guess would be the best way to put it. So that's experts and getting ready for deposition. You want to make sure as you're doing that expert deposition that you close the deposition. The closing the deposition is, have I gotten all of the opinions that you intend to offer at the time of trial? They sometimes will try and get mealy-mouthed with that, but if you ask it 4 or 5 different ways and say, now's the time. If there's anything else, you need to let me know. There is an opportunity in California state law for experts to develop more opinions and offer more opinions. And the process for that, this came through a case a while back, but the process for that is, in essence, my expert, after reading your expert's deposition, thought that there were some things that needed to be done. My expert has done a little bit of additional testing. He's done these X things. These X things that he has done have not changed his opinions. That's one way to handle it. Just let him know that what was done, and then you'll be able to bring it in. If they have changed his opinions, then to say to the other side, the work that my expert has done has changed, altered his opinions. And you could oftentimes do it as an offer of proof, bullet point, bullet point, bullet point. And should you want to take his further deposition, we will make the expert available. If you do those things, the new opinions tend to come in without a problem. If you don't do those things and your expert has done a bunch of work, then expect the judge to exclude the work and the new opinions. So just make sure you dot your I's and cross your T's on the expert side there as far as that's concerned. We talked quite a bit about state and experts. There's also federal. And in federal court, there is typically a scheduling order, and the scheduling order usually will have the plaintiffs' experts have to do Rule 26 reports and be available. And so plaintiffs have to do theirs first, then typically 30 or 45 days later, the defense has to do theirs, and there's a back and forth. So just follow the scheduling order from the federal judge, and you can't go wrong. The Rule 26 requirements are much stricter, much more onerous, and this is where working with seasoned experts can be beneficial so that you do not end up with your expert excluded for failing to follow Rule 26 requirements. Thank you for tuning in. If you enjoyed this, check out our previous episodes. More will be coming soon. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show. To all of you doing justice out there, happy hunting.